Okay, hi everybody. We're back for our third presentation today. We have Bob and Andrew who are going to talk about participant claims, and I think it's going to be an interesting conversation because we have Bob, who is an employee benefits attorney, has done some litigation, but we also have Andrew, who is an ERISA litigator. So you're going to see different kinds of sides to this particular topic. So take it away, guys.
Thank you. I am going to try to multitask and advance slides while I introduce myself. Am I going backwards? There we go. Hi, I'm Bob Seng. I am a member of the Employee Benefits Group at Dorsey and Whitney. I like to tell people that I am a sort of like a millennial in that I have moved back into Dorsey and Whitney. I was here for a dozen years, at Target for a dozen years, and now I'm back in my old bedroom. Andrew.
I'm Andrew Holly. I've only been at Dorsey. I've been here for a while, and I do largely 80%, 90% of ERISA litigation. So I'm hoping to give you some practical tips about things you can do to not only during the claims process, but avoid litigation afterwards.
And I should say that we are in the presence of an ERISA giant here. Andrew and team, a week or so ago, won successfully a motion to dismiss in a ERISA 401k plan litigation lawsuit. For those of you who have done litigation work, motion to dismiss is sort of like the judge looking at the complaint and saying this isn't going to work. So nice job.
Thank you.
We're going to pick up where we left off last year. So Andrew and I had the opportunity to speak to some of you at our first annual Welfare Benefit Forum about plan documents. And we suggested that you all take a look at your plan documents. Now, in the employee benefits world, those of us who have done retirement and welfare know that there's a big difference in how documents get treated. On the retirement side, thanks to these determination letters that have now gone away and in the way the law works, we've been very careful and precise to have a plan document and an SPD and all the other things that flow from that. Not so much on the welfare side. Compliance is sort of a it's a goal that perfect compliance. It's a goal that many will never attain, but that doesn't give you an excuse to leave it alone. Now, plan documents have a lot to do with claims, and why don't I leave it at that for my introduction and advance the slide. You should be sitting here. Plan documents.
Plan documents. So why are plan documents, why are plan documents important? We all know what plan documents are. We all know that ERISA requires them. It is, as Bob indicated in the welfare area, it is very, very, very easy to let the plan documents on the welfare side sort of slip away and to not have them in order and to have things a little bit uncertain and unclear, which can lead to a lot of problems during the claims process and a lot of even greater problems during the litigation afterwards. Probably the biggest question always, or the first question is always, is what is your plan document? And it seems like a simple question, but oftentimes it's not. You may have an insurance policy. You may have a SPD, presumably. In rare cases, you may have a separate plan document. You may have a wrap document. And it's not necessarily apparent on the face of these documents what actually is the plan. And there can be significant consequences. To give just one example of a case that I was not involved in, but that I read about, there was a claim for disability benefits, a couple $100,000. There was an insurance policy that said it was the plan document. There was an SPD that everyone really at the employer thought was the official plan document, thought that was the governing plan document. But that SPD had a little phrase in there saying, if there are other plan documents contradict this, then this document does not control. Well, suddenly we get into litigation, and many of you are probably familiar with Firestone language, the language that you have to have in your plan that gives the person deciding claims the discretionary authority to do so, and which is very, very helpful in litigation. That language was in the SPD. It was not in the insurance document. The court, which probably didn't much care, probably was looking for a reason to help the disabled person and not help the employer, found that because it wasn't in the insurance policy and because the SPD said the other plan documents control, that language was worthless. It didn't exist. Suddenly, a case that could have been won pretty early on a summary judgment motion was something that couldn't be won at all except by going to trial, and the case almost inevitably settled rather than being a victory. So again, it was a situation where everyone at the employer and everyone at the third party who had administered the claim knew exactly what was intended. They knew exactly what they wanted to have happen, but the paperwork wasn't quite put together nicely. And so when you presented it to a court, the court either found a reason or was convinced that it wasn't right and did what it wanted to do. So again, it's keeping your plan documents in control, understanding what they are, making sure that they're consistent is very, very important. Also, it's important to understand exactly what your responsibilities are under these plan documents and also your contracts with your third-party administrators. Who's responsible for what? I've had situations where the plan document indicates that the employer will make a final decision on a claim for benefits, and that's just in there at one point. 4 or 5 years down the road, people change, staff changes and all of this, and suddenly the claim for benefits comes, and the employer is surprised to find out that it actually has to make this decision. How do we make this decision? Do we really want to be doing this? Is this something? Does the TPA help us with this? It is important to understand what you're supposed to do and how you're supposed to do it. And I guess the last thing to think about here is it's also really important to think there's a lot of terms and conditions that you can include in your plan documents that can be very, very helpful in litigation. Just to give a couple examples. The first one, and an obvious one, which I assume most of you are familiar with, is the language, the Firestone language I mentioned earlier, that gives you the person making a decision the discretion to make that determination. If that language is in there and you get into litigation, your claim, the decision on that claim is going to be reviewed for an abuse of discretion, which means that if it's even somewhat reasonable, the court's going to adopt it, even if there's other opportunities, or other ideas, or other interpretations that can be made. If that's not in there, it's going to be decided under de novo standard, which is going to make it very, very, very hard to win short of a trial. And nobody likes to go to trial, and the case will probably settle for more money than you might like. Another thing that comes up quite a bit is an anti-assignment clause. One of the things we're seeing, one of the things we're going to talk about here today, is that medical providers are oftentimes getting assignments from their patients and then suing employers and TPAs en masse. We'll have cases where there's 50, 100 employers that are sued because they feel that if it's Aetna or Cigna made a bunch of decisions about a particular claim or a particular type of claim that they think is inappropriate. Suddenly 200 to 100 employees are sued in this case, and one of the big defenses that you can have is to say that the medical provider can't sue because because the claim can't be assigned to them. You have to enforce that rule. You're going to have an anti-assignment clause in your plan. And it's a situation, we've seen many situations where employers thought they had one. Unfortunately, it was 6 or 7 years out of date. The law had changed, and suddenly the anti-assignment clause wasn't really all that valuable anymore.
So Andrew, in plain English, that anti-assignment clause, what does it say?
Well, the anti-assignment clause basically says that participants cannot assign their benefits to anybody else. So if I'm a medical provider, the patient can't give me their claim, and that means the medical provider can't sue on my claim. The participant can, of course, but the medical provider can't. And if the medical provider suddenly can't aggregate 300, 400 patient claims into one multi-million-dollar lawsuit suing 50 to 100 employers, what you have to do is each patient has to sue, which is a significant roadblock and also limits the medical provider's ability to really get after you and cause these kind of chaotic lawsuits where hundreds of people are sued and they just are trying to drive a settlement just through mere chaos.
Good, thank you.
You're welcome.
Is that it?
That's all I got.
You done?
Yeah,
Okay.
that's what I got. So I guess the takeaway here is, it's very easy to let the plan, and it's one of those things, you're always trying to deal with the realities of daily life. You never know when you're going to get sued, but it is worth a little bit of time and a little bit of effort to try to make sure your plan documents are together, to make sure, not just that you know that they're together, but also that when they're presented to a court, and a judge who has no idea what's going on looks at these documents, he can finger through them, he can flip through them, and the court and the clerks and everybody will understand this is what's intended, this is what these plan documents are supposed to say. There's not chaos here, it's all very clear, and I can make a decision either early on in the case without the need for discovery, without the need to kind of figure out what's going on here.
So in litigation speak, when Andrew gets a case with documents like this, he says, we'll get this tossed, right?
Well, you know, of course.
Of course,
Yeah.
of course, of course. Okay, so plan documents, critical to claims. And really the first 2 slides of this presentation could fill 30 minutes quite easily because, you know, many of you in the room are out of it once the document request is ignored or satisfied. So a lot can be done up front to make this guy's work more efficient, easier, cheaper, if you have plan documents and if you respond properly to requests for plan documents, all right? So a number, you know, having been on the inside for a dozen years, thank you. How am I doing?
You're doing fine, but
Okay,
yeah.
okay.
So on disclosure here, I'm going to just give you a very brief background on the relevant ERISA disclosure provisions, and Bob's going to talk a little bit. There are really 2 things you need to know about ERISA disclosure obligations, and they're distinct and they get confused a lot, and it's important not to get them confused. The first obligation under ERISA 104B4 is that you have to provide the participant at request all documents, all plan documents or other documents used during the administration or management of the plan. And if you fail to do so, there's a $110 penalty. I'm not going to get into an exegesis about what documents are, what documents are responsive to a 104B request, except to say that if you ever get a letter, do not trust that they're telling you the truth about what you need to provide, because it's probably not true. The second important disclosure provision is the claims regs. The ERISA's claims regs say that you have to provide all documents that are relevant to a claim. Now, we'll talk about what that means in a couple seconds here and who has to do that, but the most important thing is that there's no daily penalty for failing to provide those documents. There's other bad things that can happen if you don't do a good job with it, but you'll see these letters all the time where the medical providers or whoever threatens damages and penalties if you don't provide the documents, and that is not true for the claims regs.
So Andrew has schooled me on this very successfully, and you know the distinction in my mind is that request that you get from a lawyer or an individual for plan documents, and they threaten the $110 a day claim. The scope that you have to respond to for those requests or risk payment of the penalty is quite a bit, wouldn't it be fair to say, quite a bit narrower than what people can ask for when a claim is actually in play. Is that fair?
It's different, but it's I would say it's different. There are different subsets of stuff, right? But you know, the 104B request obligation is fairly narrow, and there's a lot of stuff that you don't have to provide that it's a little counterintuitive that you might think you do.
And these dollar penalties are punitive, and the courts don't like to impose them if they don't have a good reason to. So, you know, often, you know, in your offices and at your desks, when you see something come across, you aren't going to know exactly if it is a claim or a request for documents. This was the hypothetical I was going to build up to, but I'm not going to do. But my take is, and what I would do in response to a broad request that might be a claim for benefits would be probably to respond to it more narrowly as though it's a request for documents rather than give them everything. Is that a fair approach in your mind, Andrew?
I think so. I mean, it depends on the particular letter and what they're saying and the circumstances. I mean, obviously, I don't think anybody's excited to have to give documents to somebody who might sue you. You know, you have to respond fairly and accurately and all that, but at the same time, there's no reason to do more than you have to do.
Okay, good. Now just a few components, a few bullets that aren't on your slide. You can take notes or you can ignore. But the chunks, the documents that are the subject of these 104B4 requests, roughly put, would be a summary plan description, a Form 5500, a bargaining agreement if there's a union, a trust agreement, and, wait for it, other instruments under which the plan is established. Now, on that other instruments under which the plan is established, that's where I'm gonna in my initial reply, if I'm in-house somewhere, I'm going to be relatively narrow on that one and let the other party come back and ask for more if they want. Like I said, this is a punitive statute. Courts don't want to impose it. There are many cases where courts have imposed these penalties, but if you take the time to read the case, you'll see that there was a lot of game playing going on before that penalty is imposed. Another sort of list for those of us who like bullets, a few components to this rule. The request must be in writing, and I would count email as in writing, but I would ignore a voicemail. I wouldn't ignore a voicemail, but I wouldn't treat that as a proper request. And the plan administrator has 30 days, and the request needs to go to the plan administrator, and the plan administrator has 30 days to reply. Now, there's play in the joints in all of these. And my advice to you guys is don't give the plaintiffs a chance to point the finger at you for kind of bad faith. And if that's the facts that we're looking at, chances of your getting dollar penalties imposed are not great. And then the other takeaway, at the risk of going over this 10 times, when you get that request that is really a request for documents and it asks for all sorts of individual materials related to that person and the likes, respond narrowly, at least initially, until you're in the claims process. Okay, you have anything more on this?
Yeah, so Bob talked about a hypothetical, so let's just talk about something that's happening quite a bit. You're living your life, you're doing your job, and suddenly you get this 3-page letter from, a medical facility called Doctors R Us. And there's
it's not too far from true.
I'm not making this up. And it basically says, it uses all sorts of threatening language, and it has whole sentences in capital letters in bold, trying to tell you. And I'm not making that part up. They think that somehow that's threatening. And it will say, your TPA is egregiously manipulating ERISA, and you are not providing us documents. And they'll demand all documents, and basically what they'll be saying is that your TPA is not paying for a particular drug or a particular surgery, maybe because it's experimental, maybe because it's not medically necessary, but they're doing it for maybe dozens or maybe hundreds of your plan participants, or maybe just a few. But the problem is they're doing it across the board, and so suddenly they can aggregate these claims together and have a pretty decent lawsuit. And the letter will inevitably say, under ERISA 104B, we want all documents relevant to the claims process. Well, as we just told you, that's not the right way of doing it, and you don't get penalties for that. But that won't really bother them. But more critically, as a plan administrator, you probably do, or at least arguably, you do have the obligation to be the person to provide responsive documents to the claims regs, and documents that are relevant to the claim. Well, you probably don't even know this is going on. Your TPA has all these documents. They've kind of generated all of this, and suddenly, how do you get those documents from your TPA? Do you have the process in place? Do you know who to contact? Are they going to be responsive to you? Because if you don't, and you don't provide these documents, suddenly when the lawsuit happens, they're going to be screaming and yelling about how unfair it was that you didn't respond, and how this is just one more evidence of how you're trying to conceal the truth, and again, a bunch of stuff in capital letters. So the point of it all is that when you get these things, you have to assume that there's things that are incorrect in them. You have to assume that they're not right, but at the same time, you have to take them seriously and realize that if it's not addressed properly and intelligently, it can cause significant problems, both during the claims process, but also if litigation ensues.
Yeah, I would consider, those of you on the inside, some sort of a checklist that you can use and that you can give to your internal clients that would describe what they should do when these things come in. And I'm using these things intentionally to be sort of vague. It's real easy when you're in the thick of things to see those all caps faxes that come in really literally via fax and put it in your recycling bin. But those are the things that start lawsuits. And if you can sort of mechanize the process for responding, I think you will be happy for the 1 out of 10 that turns into the big nightmare.
If nothing else, just make sure that everyone knows that if something like that comes in, it gets to you. Because I've seen situations where, you know, somebody gets the letter and they're not a lawyer, and they just like, all right, I'll send these documents out, whatever. And you know, it never really gets up to legal, and you know, who knows what they're sending, who knows how they're responding. And so if nothing else, just make sure that if that kind of letter comes in, it does actually get to you, which I assume in most instances it will, but I've seen situations where these kinds of things fall through the cracks.
Yeah. Let's see. I should say just one other thing. Occasionally, you'll get a request. I see a question. Andrea, yeah.
One of the things that letter often asks for is the contract between the plan and the TPA.
Mm-hmm.
Right, so how do you?
Is she helping you?
Okay, so it's a team.
Okay, okay.
Yeah, so can you just talk about that?
Yeah, okay, so for those of you online, you know, that thing that comes in, that initial document request often asks for a copy of the contract between the employer and the TPA. My gut reaction, and I'm not going to look at Andrew, so we'll see if he disagrees with me, is that is one of those other, that probably falls in the other instruments per which the plan is administered, and it's probably something that you have to hand over. You know, if in doubt, you know, in your reply letter, tell them they're not getting it. If they want to be more specific, be more specific. But my gut is that's probably an agreement that has to be handed over in a 104B4 request.
And this is one of those situations where it's a bit counterintuitive, because even though that it certainly it's not surprising that would be the law, there's actually some circuits where I believe you don't have to. The idea is that it's not an instrument pursuant to which the plan is established.
Yeah, that's true.
It's an ancillary agreement that the plan manages. That manages the plan, but it's not something that actually establishes the plan. Now, there's going to be different circuits where the rules going to be different in different circuits. And even in circuits where you think you've got some good case law, I would want to dig into it and make sure you're right and make sure your position is right. But it's surprising that that's one of those areas that certainly would be something that I would want to check into before I provided it. The other thing I'd want to make sure if I'm getting this from some kind of medical provider or something like this, do they have an assignment? They can't just ask for documents randomly. Do they have an assignment from the participant? And does the assignment specifically say that, not just that does the assignment specifically say that they assign the right to get documents under 104B of ERISA? A lot of these, if every time you go into you get medical services, you sign some piece of papers, nobody reads it. I read those because, it's what I do, and they're never right. And then if you can easily look at the assignment, you can demand the assignment, and when you get the assignment, if it doesn't say you get 104B documents, then say, I'm sorry, you don't get these documents. Or you can, if they just kind of vaguely say all other documents pursuant to which the plan is administered, you can say, well, thank you very much. We're not exactly sure what you're looking for here. It's a bit vague. Please write back to us and let us know. So the point always is that don't treat these letters as correct on their face, and you do have to comply with it. I'm not suggesting that you violate the law, but just realize that there's things to think about and things to talk about before you respond.
I always thought, when in-house, I'd have the luxury to sort of be proactive on all sorts of things. I quickly realized that's not the truth. But a kind of a form reply letter that's customized to your facts would not be a bad idea to have at the ready. And if you guys don't have time to do this, we could probably, do it for you for a fee. When you get the call from the lawyer saying, give me all these documents, and there's been no authorization, the fact that there's been no authorization from the individual to the lawyer isn't going to cut it. You need to send the materials to the participant, or you need to ask them to get some sort of a rep for the lawyer to hand them over. Courts have imposed this penalty on companies that refuse to hand things over to the lawyer simply on the basis that there's no authorization to hand the plans over.
And actually, I'm going to say one thing here. There's actually something terrible that's missing from this outline that I just realized. And this is, if there's one thing that you can carry away from this day, this might be the most important thing of them all, or at least we're quite up there. As lawyers, we always assume that the attorney-client privilege is going to cover everything that we say and write. And we assume that we can write things in emails that are frank and serious and fair, and that'll never get out. and that'll never be discoverable, and it'll never be serious, and it'll never be reviewed in a court. That's, of course, normally true, but if you're dealing with a claim for benefit process, if you're drafting an email, for example, you have a claim for benefits, that claim for benefits is going to go to some kind of committee, and you want to write to that committee, explain to them what's going on, explain the facts and the pros and cons and all this kind of stuff, that document will not be privileged. There is a doctrine in the world called the fiduciary exception to the attorney-client privilege that says that if somebody is engaged in a fiduciary act and the lawyer is giving that fiduciary advice about the fiduciary act, such as deciding a claim for benefits, the participants, that legal advice is really for the benefit of the participants. And that legal advice, therefore, is discoverable by the participant in a lawsuit. This is something that we see this kind of, I would say, a trip up all the time by lawyers because we're just used to that. And so that there's one takeaway there, at least you need to be careful anytime you're in a claim process because your advice may not be privileged.
Good. So we have lingered a bit on these slides, and that's intentional because this really is a big chunk of what you need to think about when you are doing claims. So we're going to motor a little bit through the next few slides, and I have successfully clicked over to the slide that Andrew is about to talk about. And I think about monitoring a little bit as sort of a proactive work that can be done to head off claims. Andrew has a little different take on it, but why don't you go ahead and take it away.
Right. So as a fiduciary, when you hire a service provider, even if it's an area you have no expertise in, health or whatever it is, your job isn't done. You do have a fiduciary duty to monitor them and make sure that they're doing a good job, that they're consistent with what they're doing, and that you're kicking the tires a little bit. As you see from the cases, there are sometimes plan sponsors get in trouble if they do a poor job monitoring their TPAs or the people they engage. And just as a matter of common sense, this becomes pretty important because sometimes, just to give an example, I've seen situations where the TPAs are deciding large claims and denying large claims, and the employee is devastated by it, and they're talking to the other employees, and this becomes a huge employee morale problem, and the employer doesn't even know about it. And frankly, if they did, they'd probably would have told the TPA just to pay the claim, and that can go on entirely under their radar. There's a lot of lawsuits, again, in these medical provider lawsuits, there's a lot of lawsuits where the TPA, where the employers are sued, and it's the sole basis for the lawsuit is that the TPAs, that they failed to monitor the TPAs, that the TPAs, the allegations will go, we're running away crazy with their failure to pay such claims, and suddenly the employers are dragged into it, and they're going to have to explain why they failed to or did a good job monitoring the TPA, or they failed to do so. And again, oftentimes these kind of disputes morph into disputes over money, where the employer failed to notice that the TPA was getting paid for this way or paid that way, and they'll say that that's a privileged transaction or something like that. And suddenly, as an employer, you're dragged into this lawsuit that way you really don't want to be, and based on stuff that you really didn't know about and didn't think you had to. So again, if there's a takeaway from this, is just make sure to kick the tires with your TPAs and make sure that you know what they're doing, know how they're getting paid, and if there's some process whereby you want to make sure that you're updated on X or Y or Z or big issues, make sure that you establish that.
Yeah, I would say that, as you sit through quarterly review meetings for vendors and things like that, if the spidey senses start tingling when you hear a description of a claim that kind of puzzles you a little bit, ask some questions, probe a little bit, because oftentimes that could be the tip of an iceberg. All right, HIPAA. Andrew said you do HIPAA, so I will do HIPAA. Remember that claims are subject to HIPAA. As we have gotten more detail in the ACCA claims regs, requiring more information when claims are denied, remember that you need to think about whether you have proper BAAs in place with other experts, whether you have permission to be kicking around the PHI that you are kicking around. Employers, in my experience, often act as advocates for their employees vis-a-vis the TPA or the insurance company. Just make sure that if during the time that you are advocating for your employee, that if you are getting access to PHI that you don't otherwise have permission to have access to, get the permission, because that might be a fact pattern where you have an employee that, if you're not successful in helping them, may not be your friend to the extent they were up front. I'm skipping over a few points, but one that has, and this is in the claims context, that has popped in my mind quite a bit with two adult children in our house. You know, it's interesting to see these EOBs come in for our kids that describe what's going on in the claim. And if you look at OCR guidance and other sort of secondary stuff around HIPAA, the general drift is that EOBs to participants, even if they are for spouses or dependents, are okay. But remember that the kind of the HIPAA path through being able to deliver these EOBs to the participants is for payment purposes. So there's sort of a minimum standard. Those EOBs, if they go to the participant, should only have enough to tell the participants what's necessary for payment purposes. So there could be EOBs that have more data in them than they should have. This is the kind of stuff that class actions are made of. So it's something that is worth taking a peek at. Over to you, Andrew, recoupment. Are we, yeah, we're close to us. I know.
So I'm not gonna, I'm being told I have to wrap up. I'm not really gonna talk about recoupment very much in my last couple seconds here, except to say that, you know, oftentimes TPAs pay benefits in error and they have to go get it back. And this could be millions of dollars, and I would, you know, it's gonna be very, very helpful to understand what's going on in that process. But there's one final point that I really think is important to make, that I do wanna make, is that what happens if you internally suddenly are faced with a situation where you have a claim for benefits and you have to deal with it. You know, you've looked at your plan document, you know who the relevant decision makers are, but at the same time, you know, what am I supposed to do to get prepped up for this? How am I supposed to do this? Again, there's a lot of more specific guidance I could give in specific situations, and there's ways to kind of control the process and manage the process. But the most important thing to remember if you're doing this is remember that, you know, as a lawyer, you probably want to, you naturally want to see this as an adversarial process, right? I mean, that's what we as lawyers do, where there's somebody on the other side and we're dealing with them and we're representing our client and we're dealing with that way. And that is, although maybe counterintuitive, that's bad advice when you're dealing with a claim for benefits. Remember that a claim for benefits is supposed to be a full and fair review. And if you do that right way, and if you, for example, a lot of times you see in-house counsel who are wondering whether or not they should give the bad facts to the committee, right? Because it's just naturally, it's like you feel like it's an adversarial process. It may be counterintuitive, but it's the worst thing you can do in a claim for benefits process, because if you do things like that, and it seems like it's an unfair process, if you ever do get to litigation, it can cause very significant problems. It can make it very difficult to defend the case. And if you do it right, and if you you make it a fair process, and you know, it can make it much, much easier in litigation. So again, there's a ton of specific advice we could give on how to handle internal claims for benefits and how to deal with it. And I talked about the fiduciary exception a little bit, but the most important sort of guideline I'd provide you, the principle to provide you, is remember, you have to think of it counterintuitively. This is not an adversarial process. You are doing your very best to make sure that the participant claim is reviewed fully and fairly. And if you do that, once again, counterintuitively, it will benefit you in the long run.
You want impartiality. You want the James Comey standard for review.
That might be disputable.
After today, he may have time on his hands to hire out. Disability regulations, new claims regulations for disability claims. Many benefit plan, welfare benefit plan claims are around disability. New claims effective for new claims regs effective. We're going for claims filed on or after January 1, 2018, and they apply to any benefit, think on your pension side, that is triggered due to a disability. So take a look at your processes for those. All right, we're done.
Thank you.
Thank you.